All right, welcome everyone. I'm Jeff Leslie. I'm the Director of Clinical and Experiential Learning here at the Law School. This is our information session on our winter spring field placement clinics. Those are the Poverty and Housing Law Clinic and the Prosecution and Defense Clinic. And we're joined by Professors Lawrence Wood, Professor Molly Armour, and Professor Lisa Noller. So what we'd like to do today is I'm going to turn it right over to our faculty guests to talk about their clinics. And I think we should save questions for the end, and we should have plenty of time for questions from students. If any of the presenters have slides to share, we do have that turned on for you. So let me know if you have any problems with that. So Professor Lawrence Wood, let's start with you. Take it away.
Thanks, Jeff. I do not have any slides. I'm Lawrence Wood. I'm a supervisory attorney in both the Housing Practice Group at Legal Aid Chicago, which is the Midwest's largest provider of free civil legal services to people who are living in poverty or otherwise vulnerable, and in its recently created subsidiary, Legal Action Chicago. Legal Aid Chicago receives funding from the Legal Services Corporation, and therefore it labors under LSC restrictions that Congress imposed back in 1996. And these restrictions prohibit our legal aid attorneys from filing class actions and engaging in legislative advocacy. Legal Action Chicago receives no LSC money and is therefore free to engage in the impact work that Legal Aid Chicago cannot do. Now, Legal Action has just 3 attorneys. The executive director, John Bowman, worked at Legal Aid until 1996 when he and several of his colleagues who were frustrated by the new LSC restrictions left to join the Shriver Center, which John led until last year. John supervises me, and I supervise Rachel Wilf Townsend, who came to us after clerking first for Merrick Garland and then for Sonia Sotomayor. So I'm sure I'm the worst boss she's ever had, but it's a good small group. As I said, we just got started, and I'm going to soon talk about the first class action that we're intending to file if we can't settle the case. If you do take my class, which is offered during the winter and spring quarters, you will attend a weekly 2-hour lecture here at the law school, and then you'll work on actual cases about 12 hours a week. And though I will be working full-time with Legal Action Chicago come the new year, most of your cases will come from the Housing Practice Group and involve the direct legal representation of individual clients. You will also, however, have the opportunity to work on housing-related impact cases and initiatives with Legal Action. Now, through your work with the Housing Practice Group, you'll be exposed to the practice of poverty law by interviewing clients, conducting investigations, doing legal research, drafting and answering discovery, writing briefs and motions, representing clients at administrative hearings, and if you have a 7-Eleven license, conducting depositions and trying cases under the direct supervision of experienced litigators in the group. By the time the class ends, you'll know what legal services work involves and whether you want to pursue it as a career, like 2 of my former students, Rachel Zemke and Stephen Scheuer, who are now my colleagues, or by taking cases pro bono. Now, the Housing Practice Group focuses primarily on defending against unfair evictions and contesting unwarranted terminations of rental assistance. But we also challenge unlawful discrimination. We force landlords to make necessary repairs. We represent individuals who have been improperly denied admission to subsidized housing programs, and we help preserve the affordable housing stock. But most of our work in the Housing Practice Group consists of eviction defense. Now, some of you may have read Matthew Desmond's Pulitzer Prize winning book, Evicted, Poverty and Profit in the American City. And Desmond argues, and I agree, that evictions are not a symptom of poverty, but a direct cause. And he concludes that they constitute, quote, one of the most urgent and pressing issues facing America today. And that's certainly true here in Cook County, where before the pandemic-related eviction moratoriums that went into effect, well over 30,000 eviction actions were filed every year, usually against low-income tenants. Most of these tenants have small children or household members with disabilities. Many reside in subsidized housing, much of which is not far from the law school. So if they get evicted, they will lose not just their apartments, but the rental assistance that runs with their units. And because anyone who is financially eligible for subsidized housing cannot afford market rent, they will likely become homeless or have to move into poorly maintained and overcrowded units. Many low-income tenants who are facing eviction have meritorious defenses. I think most of them do. But what they don't have, because they can't afford them, are lawyers to help present these defenses. And that's where we come in. Now, the best way to give you a sense of the work that we do is to describe a single legal aid eviction case that may lead to Legal Action Chicago's first class action. My client, whom I'll call Ms. K, is a single mother of 6 children, and they all live in a Chicago Housing Authority public housing development called Alta Gardens, which is about 13 miles south of the campus. Like all CHA public housing residents, Ms. K pays a reduced rent equal to either 30% of her adjusted gross household income or the minimum rent of $75 a month, whichever is higher. Federal law authorizes, but does not require, CHA to charge families this minimum rent. CHA contends its minimum rent policy is central to its effort to make tenants self-sufficient. But this contention is based on a racist assumption that my colleagues and I reject. And that assumption is that CHA's public housing residents, 96% of whom are Black or Latino, do not want to work and will seek employment only if they are forced to pay rent. Now, federal law does require CHA to grant what's called a hardship exemption to the minimum rent requirement to any tenant that is facing what is called in the statute a financial hardship, such as a death in the family or a loss of employment, or even a risk of eviction for non-payment of the minimum rent. CHA, however, does not grant a hardship exemption unless and until a family formally requests one. And that's a problem, because most CHA residents have no idea the hardship exemption even exists. CHA buries information about this exemption in the middle of its single-spaced 34-page lease agreement and 104-page single-spaced admissions and continued occupancy policy. It takes no other actions to inform families about their right to request and the process for requesting a hardship exemption. CHA uses rent adjustment notices to inform tenants that they must start paying $75 a month in rent. These notices do not state that the $75 represents the minimum rent, nor do they mention anything about the right to request a hardship exemption. They do include information about the tenant's household income, and when this income is less than the minimum rent, and it's often zero, CHA should know the family is entitled to a hardship exemption. I have, over the past several years, represented several CHA tenants who received these rent adjustment notices and complained to their property managers that they could not afford to pay the amount demanded. Instead of informing these tenants about the right to request a hardship exemption, the managers told them to sell a portion of their food stamps, which is illegal, of course. To understand the scope of the problem caused by CHA's deficient policies, consider the fact that CHA charges its lowest income residents, many of whom survive on nothing but SNAP benefits, formerly known as food stamps, about $1.4 million a year in minimum rent payments. Ms. K, my client, was one of these tenants. She received a rent adjustment notice telling her she had to pay $75. She couldn't afford to pay this amount, had no idea that she could request a hardship exemption. So after a year, CHA filed an eviction action against her for non-payment of $900, which was a year's worth of minimum rent payments. I took this case to trial and I won, but on an issue unrelated to CHA's failure to notify Ms. K about her right to request a hardship exemption. And CHA subsequently refused to remove from Ms. K's rent ledger the minimum rent charges, though it has not yet filed a new eviction action against her. So Ms. K is now one of 3 named plaintiffs in a class action complaint we are prepared to file unless we're able to settle the case. We actually are hoping to settle it next week. Our complaint alleges that CHA's policies violate the federal minimum rent law and the due process clause of the 14th Amendment. And we are seeking policy changes, revised notices, trainings for property managers, and an order requiring CHA to reimburse tenants for minimum rent payments they actually made and to adjust the tenants' ledgers to remove minimum rent charges they did not pay. If this kind of work sounds compelling, if you believe that our system of justice works only when people have meaningful access to it, regardless of their ability to afford an attorney, if you want to provide representation to low-income families and think you'll enjoy client contact. And if you want to help indigent tenants who live just blocks from the law school, then I hope you'll consider taking my class. You can learn more about it by reading the course description on the law school's website. And I just want to end by saying that this will be my 22nd year teaching the class, which has been one of the highlights of my more than 30-year career as a legal aid attorney. If you want to talk to me about the class to see if it's right for you, please call me. My number is on the school's website. It's 312-347-8330, or email me at the letter L and then wood at legalactionchicago.org. That's it, Jeff.
Fantastic. Thank you, Larry. Now let's turn to the Prosecution and Defense Clinic, Professor Lisa Noller and Professor Molly Armour.
Larry, I want to take your clinic.
I also want to take your clinic.
You can.
So we're going to introduce ourselves, and then I'm going to provide some background and then turn it over to Molly. But I'm Lisa Noller. I am the National Chair of the Government Enforcement Defense and Investigations Practice Group at Foley and Lardner, which is just a fancy way of saying that I'm a white-collar criminal defense lawyer. I have been here for 11 years, and before that, I spent 10 years as a prosecutor in the U.S. Attorney's Office in Chicago. Molly?
Hello, all. My name is Molly Armour, and I am a solo practitioner with a criminal defense practice. I am based obviously in Chicago, downtown, and it's primarily federal. And I've had that practice for over 10 years.
So thank you guys very much for expressing an interest in the clinic. I'm pretty passionate about it, and I'd like to tell you why. So I graduated from the law school 26 years ago. And when I was there, the clinics existed, but they were on campus only. And the school did not give credit for externships at places like the U.S. Attorney's Office or the Federal Defender Program. Many of us pursued those internships anyway, and it was to our benefit. So what an internship at the U.S. Attorney's Office and the Federal Defender Program does is, like Larry's clinic, it introduces you to what it is like on a daily basis to be a part of the criminal justice system on either side. If you have a 7-Eleven license, you have the ability to work on federal cases that are in trial. You can interview witnesses. You cannot appear in the grand jury, but that's about the only thing that you cannot do. You can try petty offense day cases. You can put witnesses on the stand during hearings, trials. And a lot of times, because there aren't associates like a typical law firm structure, at least in the U.S. Attorney's Office, we had interns as the second or third member of a trial team with some regularity during the course of their externships. So when I graduated from the law school, it became my mission to figure out a way to make those externships credit worthy. And one of the reasons is because it's a deterrent to not get credit for an externship, right? I know you guys are incredibly busy with journals and moot court and course obligations and clerkship applications and everything else you're doing. So that is how we came to design the clinic. Here's what the clinic is. So you on your own get an externship. Actually, Susan Curry can help you. We can help you. I shouldn't say you're totally out on your own, but you have to apply and get accepted to an externship with the U.S. Attorney's offices in Chicago or the Northern District of Indiana, or a state's attorney's office in and around the collar counties or in the city of Chicago, or any number of other government agencies on the prosecution side. So we have had folks for antitrust, the criminal division of the Attorney General's office. I think that's it but we're open to any government agency position. Or you can work on the public defender side for any state public defender or the federal defender program. And what that does is it puts you into a day-to-day criminal justice environment. And when I say criminal justice, I choose those words carefully because you are working for and on behalf of the criminal justice system, regardless of whether you're a prosecutor or whether you're a defense lawyer. And one of the things I think that I'm most proud of, having done both, is that really, especially in the city of Chicago, all of the attorneys in this bar know each other. We all endeavor to get to the right result, and we really are trying to make sure that the public is protected, but that punishments are sufficient but not greater than necessary to effectuate the principles of the criminal justice system. So the course, after you get your externship, what the course does is it gives you up to 7 credits. It is winter and spring. And you meet with Molly and me for 2 hours on Monday nights. And we basically go through from the beginning of the course to the end, a modified trial ad course. So we take the life of a couple of reactive criminal cases. So you're representing somebody who gets arrested. You look at it from the defense side. How does that case play out over time? Or if you are on the prosecution side and you're investigating a matter that's reactive, so a bank robbery, an illegal reentry case, a buy bust, and a drug defendant. Those are some of the more common reactive cases. What do you do to ensure that that person is sufficiently prosecuted? We take that from both sides and we go through the entire anatomy of those cases throughout the course of the clinic. It is unique in that you get both perspectives, and there are people from both sides, the prosecution and defense side, meaning you, who are in the externships, living and breathing these cases over time. Most clinics, you like Larry's, you are representing an individual just on one side of the case. In this clinic, you're working both on behalf of the government and on behalf of the individuals. The participation in your placement is something that we monitor. We make sure that you are getting substantive work, that you are being utilized as the smart law students that you are. So it is not a case where, or not the case where you're just going to be taking notes or carrying somebody's briefcase. You're going to be actively participating in the litigation matters that the U.S. Attorney's Office, Federal Defender Program, any other externship provides. That is half of your grade. The rest of your grade is comprised of various participatory endeavors within the course. So it is a very, very active discussion group every week. It is not a lecture format. Everybody has readings, and then we talk through the readings, figuring out the social justice aspects of the readings, the ethical aspects of the readings, how it plays out in an actual criminal case, etc. We also, because the externship is such a significant portion of the course, and because I believe it's required, there's a journaling component to it, which we talk through as well. So what are you learning? What are you seeing? What do you think the criminal justice system should be doing differently? And then lastly, there's a 10-page writing requirement, and that is 95% of the time satisfied by turning in something that you have done throughout the course of your externship. So for example, if you have written a response to a motion to suppress, a response to a Seventh Circuit brief, a motion to suppress, those are all substantive, a memo, a research memo, those are all substantive materials that we will accept in furtherance of the grade. And Molly, do you want to talk about, you can talk about anything you want, but if you want to also talk about maybe the substance and arc of the class, that'd be great.
So Lisa kind of touched on what we're really doing in the classroom component is really teaching you the arc of these cases. And what we really hope that you're able to leave with at the end of the clinic is a real understanding of how these cases progress through the system and the dynamics around each phase of those cases. So in that way, we kind of have this arc that tracks the life of a case. We of course begin with like a good ethical route. And talking about, where we're coming from, what these things are about, what are the values inherent. And we have this oddity where we have like adversaries in this clinic, right? The prosecution and the defense. So it's like we're talking about this where both parties kind of meet that. And what are the core principles around the system? And then we take it to the life of a case. So we have some really things that I really like about getting on your feet. Doing like a bond hearing, which we've been able to do pre-COVID before an actual magistrate judge, where you argue for bond for a client and we give assignments, and some people will argue against bond, and working with the statute and working with the fact patterns and really getting on your feet and doing that. We try and like lace those kinds of experiences all throughout. So that you're doing that both in the classroom component and hopefully getting some measure of that in your external placement. And then we just continue going through cases, different kinds of issues. I think a core thing that Lisa and I have had in this course for a long time is an over discussion about the racial and economic realities of the system that we are dealing with. And I'm sure at this moment in time, every person who's on this call is also likewise aware of all those dynamics. And that's something that we feel is important to address head on. So that kind of is in the middle of our discussions. And then we continue on with sentencing, trial, and all the components in between, and really talking about how we are advocates for those roles. And one thing that I really like is we kind of look through the life of a courtroom through this very Chicago, very specific, but very true experience in a book that we will read and then weave out through in that, which is Courtroom 302. And we'll have discussions about what we see at 26 in California, just right outside there. We've talked a lot about the federal. I primarily do federal work, and so does Lisa, but having a state experience is also, really valuable, both in this course and I think in life. If anyone is interested in pursuing this path, that's really where the bulk of the work is and where the bulk of the system is affected. So the Cook County State's Attorney has taken externs before. We have a relatively new state's attorney, Kim Fox, and we know that she's trying to do different kinds of things. So that's a really interesting placement to be at a state's attorney's office when there's a philosophical shift that's going on. Because it's also interesting to look at these things systemically, not just in a practice point, but what does it mean to be a prosecutor in those kinds of offices? And then the same kinds of shifts is happening at the Cook County Public Defender's Office. There's a brand new public defender, Sharon Mitchell, and he's definitely taking a different tack as a public defender's office. So that's also an exciting moment to kind of be involved and kind of see that on the ground. So I just want to flag that those are placement possibilities. I know people tend to really like the federal, but I think those are really exciting ways to get that experience. And I do want to say from a defense perspective, which is my sole perspective, because all I've ever done is defense. I do think that there's something so powerful about representing human beings and getting to participate in the process of representing people. And I was very inspired by what Professor Wood was talking about, because we're really talking about the lives of individuals, and what we see by and large is a system that is really rooted in poverty. So you're going to be dealing with a lot of the same issues that the same tenets we're kind of talking about. There's a whole intersection here. And I think it's really powerful to get to see those lives if that is not an experience that you come from. And I think that's really something important to think about. But I really think it's joyful to be able to work with real people and to begin to put your experience at the law school to work, right? And this is this exciting thing that it is so great that Lisa really blazed this trail to get this clinic to happen so that you can get this credit experience while getting real lawyering in your bones, because that's what the work is really going to be. And it's exciting to be able to have a touchstone with this, criminal backbone that we're going to give you, but also to get in there and start doing this experiential learning that I think is so important to good lawyering.
I'm going to make one other plug. And I neglected to mention this when I was speaking before, but I was also one of the hiring people for the U.S. Attorney's Office when I worked there. And there is a strong preference for hiring people who have had internships and know what it's like to be on the ground actually having prosecution experience. I don't know if the defense side has the same bias, but just know that if it's something that you are thinking of pursuing at some point in your career.
Yes, and I will just echo exactly what Lisa said for the defense side. I think it's really important, especially nowadays for public defenders, to really see commitment to our clients and to the larger issues at play. And so having that experience is going to be really important and will give you an absolute leg up. And it'll also help you understand how you navigate that system and really what that's about. And I think because these are very powerful but also very intense jobs, I think it's also, if it's something that you think you may have interest in, there's no better way to find out whether this is a good match for you then really getting in the courtroom, getting in these offices and seeing if that works for you. And I think this is a really great opportunity to do that with credit.
Thank you both. That was a great overview. And now let's open it up for student questions. I'm happy to play moderator. While you're thinking of questions, I may just address one point that came up in the presentation about 7-Eleven licenses that was mentioned. So this is the Illinois student practice rule that permits law students who have completed half of their credits towards their degree, allows them to stand up in court under the supervision of a licensed Illinois attorney. So that's the 7-Eleven rule that comes into play in these litigation contexts. I see we're joined by Susan Curry. Susan, do you want to talk just a little bit about your experience in the process for looking for the externships for the prosecution and defense clinics? I know you're very involved in students who are looking in those areas.
So before we had this clinic, students were still seeking internships or externships at legal aid, and defender offices, and prosecutor offices. But those always had to be completed for just pro bono hours, no academic credit at all. And as Molly mentioned, the idea behind this is to get academic credit because you're also experiencing the classroom-led context, and there's time for reflection and all sorts of pedagogical aims are met here. The challenge, of course, not so much with Larry's clinic, but for the prosecution and defense clinic is finding that host, especially since you have to oftentimes do it before you've even registered for the prosecution and defense clinic. I think that happens somewhere in late November. And as you may have already discussed, finding the host agencies, especially the federal ones, the U.S. Attorneys of Northern District and the Chicago Federal Defender, tends to want applications earlier. So you might wonder, what happens if I just don't ever find the host, and that is required. Any prosecution entity, so either Cook County or the feds, and any of the collar counties will work. And on the defense side, you can also include community defenders. We have a few. Some will require a car, but McMoran Center up in Evanston. Others are right down in the neighborhood, Lawndale Christian, Cabrini Green. But appellate work, not so much, right, ladies? We're not doing that. Doesn't really make sense. I think as you just heard the goals of that Molly and Lisa laid out. So it's a great opportunity, you in the record, but not quite what was in mind for this prosecution and defense clinic. So if you're thinking about doing it, just look on the page, go to the sites early, contact me. I'll send reminders out, but as I say, given the nature of it, you often have to do things what will feel like a little out of order for you.
Thanks, Susan. I see there's a question in the chat about expectations around the externship opportunities being in person. Do our faculty want to address that for the students?
I know that the U.S. Attorney's Office is back in person and the interns have been showing up. I don't know about the other agencies, Molly. I don't know, but if you know.
Yeah, I don't think we have full information about all the agencies, but I do know that all the offices are back on at least a hybrid basis. And I think pure remote, as we are right now, is thankfully something that we are not currently doing. Of course, we know that this pandemic can have a life of its own, and we all have to just be flexible with that. But we didn't have the clinic kind of last year because we were, concerned about the importance of having this engagement. I think we're all really well practiced on straddling that line between in-person and virtual learning right now. And I think we're confident that people will be able to get those experiences.
For the Housing and Poverty Law Clinic, last year I taught it remotely, and there are challenges with that. Obviously, the biggest disadvantage was that the students did not get to meet in person with clients and conduct in-person interviews. And we are going back now to our main office, which is in the Loop. It's at 120 South LaSalle in what's called the Private Bank Building. And the attorneys are coming back. You just have to show that you're vaccinated. And we hope by the time the clinic starts to be back to doing in-person interviews. And certainly I plan to teach the class in person.
Whether the clients are able to come in or not, is the expectation that students will be on site at Legal Aid Chicago, interacting with the supervisors and doing the work over there.
That's right. That's right.
Okay, good to know. Great. And any other questions from the students? Anything that the panelists want to add?
Hope to see you in January.
All right. Well, thanks everyone for joining. It's great to see all the interest, and thank you to our faculty for making time to join us. And we'll give everyone back part of their lunch hour.